Good evening, friends. I'm delighted to welcome you all this evening for the Media Foundation IIC Media Dialogue on new criminal codes and media laws. Which way media freedom? That's our question here today, which the panelists will try and tackle. These are the discussions that we hold once every quarter. We're trying to keep to time on the calendar on an important issue related to the media in the country. Today's topic covers certain critical developments in recent months. The new criminal codes, the BNS and the BNSS, have widened the ambit of the law related to sedition and criminal defamation, although the law avoids using the term, and this could have a very serious impact on the media. The confusion over broadcasting services regulation bill continues. I think all of you are aware of the flip-flop that's going on, and the jury is still out on where we really stand on it. And lastly, last month, the Maharashtra government introduced a bill to curb so-called Naxalism in urban areas. The bill was draconian, it has draconian features, and could once again have serious repercussions for freedom of speech. So all these are going to impact the media in a big way. We have an excellent panel here to debate and analyze these issues, but just before I introduce them, please allow me to say a few words about the Media Foundation. The Media Foundation was set up in 1979 after post-emergency with the aim of upholding freedom of speech in the media. Its founding members were such doyens of Indian journalism as B.G. Verghese, Ajit Bhattacharya, Kuldeep Nair, Arun Shourie, and others. As you can see, late 70s, the women hadn't yet reached the editors' rooms, but after that, the story has changed. Apart from the media dialogues, we hold the prestigious Chameli Devi Jain Award for an Outstanding Woman Journalist of the Year. We also hold the annual B.G. Verghese Memorial Lecture in memory of the late founder. We've just started a website, and I'm very excitedly sharing this with you. And Shuma Ra, General Secretary, Bharat, Prashanto, and others have really worked very hard on it. It's called themediafoundation.in. Do log in and see all our activities there. You can, run into all the various programs that have been held, the videos, etc., including today's. May I now introduce the panel? We have with us Sanjay Hegde. He's a senior advocate at the Supreme Court and a frequent commentator on legal issues in the print and visual media. Sanjay, say hello.
I said in the
Akash
spirit
Banerjee.
of the Samhitas, I said namaskar.
Akash Banerjee, he's a social and political satirist and a new media entrepreneur. After spending a decade and a half in traditional media, he became the founder and host of the Desh Bhakt, India's first and largest social and political satire platform. Jyotika Kalra is an advocate on record at the Supreme Court of India. She's a former member of the National Human Rights Commission and the author of 3 books. Her writings on law, women's rights, human rights have been featured in several newspapers and magazines. Paranjoy Guha Thakurta, our friend and Media Foundation member, is a senior journalist, needs no introduction with all the books that he's written, each one talking truth to power, author, publisher, documentary filmmaker, and music video maker and teacher. If you haven't seen those music videos that came out during the elections, you've missed something. Arghya Sengupta, is everybody saying hello to the audience as I call out their names? Is the founder and research director of Vidhi Central for Legal Policy. His areas of specializations are constitutional law and regulation of the digital economy. He's the author of 3 books, including the recent The Colonial Constitution, published by Juggernaut in 23, that deals with why the Indian state has always towered over its citizens and continues to do so. Manish Chhibbar is going to do the honors today. He will moderate the panel. Manish is an award-winning journalist who has helmed newsrooms in the Indian Express, DNA, The Print, and among others. Many scoops on the judiciary. Manish, it's over to you now.
Thank you, ma'am. Good evening, ladies and gentlemen. I hope everybody can hear me. So here's how we plan to take it forward, because like most of you, yeah. So like most of you, I'm also here just to hear these gentlemen and the lady here. So here's how we plan to take it forward. We'll have opening remarks, 4 to 6 minutes from each of the panelists, and thereafter there'll be small rebuttals followed by question answers. So if we could start with Paranjoy.
Thank you, Manish. Thank you, Media Foundation, for asking me to speak here. There are at least 3 experts on the law, on the laws. I don't pretend to be one. They will surely give you a lot of information on not just the broad pictures, the objects, but also the fine print of not just the 3 laws that have replaced the Indian Evidence Act, the Indian Penal Code, and the Criminal Procedure Code, but also other laws such as the Press and Regulation of Periodicals Act of 2023, the IT rules, which has a real tongue twister, Information Technology Intermediary Guidelines and Digital Media Ethics Code Rules 2021. And of course, we must not forget the Digital Personal Data Protection Act. My limited understanding of the bills and the laws as they are proposed to be changed is that they would give overriding powers to the government and government agencies to control what you watch, what you hear, and what you write. Now, I'm sure the people here would be able to tell you far, far more than I have about how the situation will work. So I'll try and focus on the bigger political picture because I think there will be others who will be able to say much more than I. The political situation that we see today and the fact that there is a possibility that the broadcast bill has been withdrawn. We only have newspaper reports, we only have media reports, quoting sources, usually reliable government sources, but it seems it has been withdrawn. And it may be unrelated, but the bill to amend the Waqf Act has gone to a joint parliamentary committee. The proposal to have lateral entry into the civil services has been withdrawn by the Union Public Services Commission. And most recently, the National Film Development Corporation is apparently having second thoughts about going ahead with a festival of films made by Israeli filmmakers. This is all writing on the wall the way I see it. Clearly, the government or Modi 3 is not the same as Modi 1 or Modi 2. I mean, just the numbers. So whatever may be the front, whatever may be the impression that the Prime Minister and those who are close to him may want to give, there is a difference between 303 Lok Sabha seats and 240 Lok Sabha seats, and everybody knows, and I'm sure he also knows. So I think that what has been happening and what is going to happen would also be greatly determined and influenced by the bigger political situation. I think one point that has been made many times before, but I think it needs emphasis, is that Shri Narendra Modi is the one and only Prime Minister of India who's never had conducted a press conference where any journalist, or even if journalists accredited to the Press Information Bureau, are called and they can ask him any question. Every single Prime Minister of India at some point of time or the other has had such a press conference. Yeah, it is his right, it is his prerogative not to have a press conference, but I'm stating it as a fact. And these are unscripted, spontaneous press conferences or media conferences. He has picked and chosen people who he has given interviews to, and you're welcome to see them. My understanding is that He's given interviews to those who are ideologically inclined towards him, and he's also given interviews to people who have not asked him follow-up questions and not asked him difficult questions. This is my personal view. He may disagree, others may disagree, but the point is, for want of a better phrase, goody questions have asked of him, and no follow-up has happened to those questions after he's answered. Say, for instance, this thing about Notbandi and employment. He got away by saying, see that guy outside the Z studio frying pakoras? So this is something which is very, very important about him. Ruvika Liaquat never thought of asking him why he was not biological. Why he believes that, Paramatma ne unko bheja. I think any journalist should have asked a follow-up question. But she chose not to, for reasons best known to her. Modi ji has also given interviews to people who are not journalists. Again, he has every right to give interviews to Prasun Joshi, who talks about how hard he works. The famous interview by Shri Akshay Kumar, what his driver had asked him to ask the Prime Minister, आप आम कैसे खाते हैं, काट के खाते हैं, चूस के खाते हैं, these kinds of important questions he feels. So this, in my opinion, creates a certain atmosphere where large sections of the media are become the Goti media, to use Ravish Kumar's favorite well-known phrase. You are the lapdogs. You're not watchdogs. You're not even a guide dog. You're a lapdog. So that's where you come from. I think never before, perhaps excluding that 21-month period between June 1975 and March 77, has the media been so subservient to those who are in positions of power and authority. So this has set the tone for what has come. It's hardly a secret, it's a no-brainer that sections within the ruling establishment are concerned, within quotes, about the popularity of Akash Banerjee, Deshbhakt over here, of Ravish, of Dhruv Rathi. They can't do anything to Dhruv Rathi because he's in Germany, or sometimes he's in Australia, sometimes he's in Netherlands, just as they can't do anything about Hindenburg because it's in New York. But what he can do is people like Akash or Ravish Kumar. And therefore the attempt to bring in YouTubers, those who work on the social media, and bring in the old stories, the security of the state. आप मेरा साथ नहीं है, मतलब आप देश के खिलाफ है, आप देशद्रोही है, आप राष्ट्रद्रोही है. That discourse is dominating. And what I will say, that the kind of intrusive authorities that they've given, anybody can enter anybody's premises for whatever the purpose might be at whatever time. I was privileged to have the Delhi police come to my home at 6:30 in the morning, 8 of them. My wife was in a generous mood, offered them tea and biscuits. Others were not so lucky. For reasons best known to the Delhi police, they returned my phone. As we talk now, there are 300 personal electronic devices with the Delhi police, a special branch, just a stone's throw from here. Now, these things are happening for the first time. It's never happened before. That the homes of 60 journalists were simultaneously visited by the Delhi police for their association with NewsClick and so on and so forth. So all these indicate that साहब क्या सचमुच घबरा क्या बातों में क्यों घबरा रहे हैं? This is why I wonder that despite the power that he has wielded, and yes, admittedly he's not as powerful as he was in the first 10 years, why is he so insecure? Why does he want to control the narrative? And I dare say that within the government also there is a huge debate going on whether these measures will be counterproductive or not. And that's a good thing, that if the broadcast bill is withdrawn, it's a very good thing. It will happen. Whether it will or not, I don't know. Whether it will have a new avatar, and again you'll be asked. As of now, the official position is you can still have time till the 15th of October to respond to the old bill. I don't think there's ever been a case of draft bills being circulated within a limited group of people in watermarked. And this is that, so that you know you have given it to A or B or C or D, and that person had to return it. I don't think these things have ever happened before in this country. तो अच्छे दिन आ गया हमारे लिए, समय बताएंगे और कितना अच्छा होने वाले है. That's all. Okay, Mahesh?
Right. Wonderful, sir. So I'm sure, we'll discuss all these issues in detail once we are through with the opening remarks. So can we have Sanjay Hegde, senior advocate, to speak on?
Well, taking on the Achhe Din theme, one of the things about rulers is that they like to be remembered for all time. So I think that what we now have in the 3 criminal laws can be appropriately called the Modi Code, like the Napoleonic Code, which gave law to France, or Solon or Hammurabi. So it is in that tradition that we've suddenly had these 2 new Samhitas and the Evidence Act. The point is, what have they achieved? What they have achieved is a tightening of the state. Everything has been tilted in favor of the state and against many of the judgments which had opened out the crevices of freedom in what is still largely a colonial state with a police legacy which we inherited from the British and have continued all these 75 years. It was a journalist who once told me that India actually works on what he called the Thanedar principle. The Thanedar, and there are about 6,000 of them in India, 6,000 odd police stations. They have a local jurisdiction. They do not want anything to go awry in terms of order in that jurisdiction, and they want to pass it on peacefully after they retire or are transferred. So, if you have somebody who is exercising his constitutional rights of free speech, that then causes some others to respond, then you have a disturbance. The moment you have a disturbance, you have the administration on the Thanedar's head asking what's going on, what's wrong. So what is the easiest thing to do? The easiest thing to do is to lock up the troublemaker. You put up a Facebook post, and that caused all these disturbances, we'll put you inside. Then let the courts deal with them. Now, with the new Samhitas, these things can get even more draconian. There are 6,000 police stations. Any of them can register a 0 FIR. So somebody in Itanagar can just take note of what I've said here and say, look, my sentiments have been hurt, and I'm filing this FIR in Itanagar. Let them transmit it to the relevant police station. Let investigation begin. Now, what does an investigation then do? An investigator can always lock me up. And previously, I could be in police custody for about 15 days. No investigation actually required custody for 15 days. And after 15 days of police custody, the courts would normally set you free. Once you went into judicial custody, which meant you were in jail, and court said, how long do we continue feeding these people? Let them out. Now, what's happened is that the provisions for police custody have grown greatly, up to 60 days and even up to 90 days. So 3 months in police custody. And those 3 months, how do you count them? You do not count them like I went into police custody on day 1, and therefore at the end, on day 91, I can apply for bail. The police can take you in for 5 days and say, okay, we don't want, our investigation is going elsewhere. For the moment, we are returning him into judicial custody. But we have 85 days still. And they can go on in installments, and it will be a brave court which will say that, look, you've had custody of the man long enough. This is the crime alleged. I don't think you need that much time for investigation. Though after 15 days, there are some safeguards. But those safeguards will all now be dependent on judicial interpretation and the very power of the policeman, and not necessarily the policeman of the area that you reside in. Even the man in Itanagar decides, no, I'll investigate it myself before I decide whether I have jurisdiction or not. He can quite conceivably come here, pick you up, take you to Itanagar, give you some free hospitality of the state out there. So the thing is, this kind of chilling effect or the Iron Curtain dropping has been enabled primarily by the fact that for the past 10 years, we've had large sections of the media who have preferred to be complicit in the governance of the day, and where we were assured of maximum governance and minimum government, we have had it quite the opposite. The question is, where do we go from here? Does the media and does civil society take up the challenge? And they have no other option but to take it up. Each of those sections, in an appropriate case, will have to be challenged, will have to work its way through the courts, and its constitutionality determined. But in the meanwhile, the person who has been arrested on a complaint from Itanagar will be a sacrifice to the Samhitas. There was Justice Krishna Iyer's famous phrase of martyrs of the Constitution. And I think there will be many, many sacrifices to the Samhitas. And the worst of it is that the nature of power is such that when the state tastes unbridled power, it does not give it back. You may have a different government, but I really doubt that there will be any government which will say, okay, we will now scrap this, go back to the old system with its protections, or add more protections. That kind of government or that kind of demand on legislation will come only from an informed, engaged citizenry and media. Otherwise, we are going the way that the Maharashtra government has done, where the government has wanted to define front organizations of Naxals, and it's all in the wording is so loose that the Rotary Club of Ulhasnagar could possibly become a front organization because maybe it provided relief somewhere on the outskirts of Bombay to some people who were poor, and those persons were accused of Naxalism altogether. The thing is that the state believes it is all-powerful, that it does not minister to citizens, but that it rules over subjects. The question is, are we to remain subjects of Motabai, or Motabai is watching you all the time from Big Brother? So, or are we to be free citizens and at least in our homes, in our little places, we can say that, look, as the old phrase went, that the wind may blow in an Englishman's home is his castle. Though the winds may blow in, though the rains may come, the King of England dare not enter. Today, we have no castles, we have no place to hide. And any of these 6,000 tin pot dictators at the Thanedar level can ruin a life or two. We need to be ready to ensure that there are as few sacrifices to the Samhitas as possible. Thank you.
Thank you, Sanjay. Can we have Ms. Jyotika Kalra?
So, Manish, I'm just taking this discussion to another direction. Basically, all these three amendments to IPC and CRPC and Evidence Act, there was a consistent deliberation for that. In March 2023, the discussion started, the deliberation started, and in August 23, that the team which was discussing about the proposed amendments, they referred, the Home Minister presented that the amended BNS, BNSS and BSA before the Parliament. And after presenting those three amended penal laws, they were all referred to the Standing Committee on Home Affairs in December 2023. And then the committee gave its report. The earlier bills were withdrawn, and the bills with the amendment, incorporating the suggestions from the Standing Committee on Home Affairs, the bills were reintroduced and they were passed. And this Standing Committee on Home Affairs, they had very eminent persons on their panel, including Faizan Mustafa, Vice Chancellor of Nalsar, and other very eminent persons and senior government officials. So, as far as BNS is concerned, Bharatiya Nyaya Sanhita, which is the amended version of IPC, the most disturbing part is there is no 302, 302 is no more there, 376 is not there, and 420, where we had a film also, Shri 420, that is also not there. The sections are renumbered. 302 is now 103, murder is 103, 376 is 64 and 65 BNS, and 420 is 380 BNS. There is a change in numbers. I mean, I think that change is something which comes with power, because I am remembering when Connaught Place was renamed as Rajiv Chowk, we thought that it will never be possible for Rajiv Chowk to replace Connaught Place, but courtesy metro, there's a metro station, so Rajiv Chowk is a popular name now. And as far as media laws are concerned, I think two sections, 124A, which was there in IPC, that is sedition, it is now 152, but the provision earlier, because 124A is still under the scrutiny of the Honorable Supreme Court of India, and all matters related to 124A have already been stayed. The change in this 152 is, it's not emphasizing on against the government, but it is the basic premises against India's sovereignty rather than the government. It is not, no more a government now, it is against the sovereignty of country, that is India. And because when I was reading this, so Article 19(1)A, that which deals with the freedom, and it deals with the freedom of press too, that article also has a caveat to it, that is Article 19(1)A, freedom to speech and expressions, is not absolute. It is subject to Article 19(2), and as per Article 19(2), it includes, 19(2) includes power with the government to put reasonable restrictions in the interest of sovereignty and integrity of India. So as far as reasonable restrictions in the interest of sovereignty and integrity of India, that is a constitutional mandate. And then further there is another section in BNS, that is 113, that deals with the terrorism, and that can also be counterproductive to media laws. That has been added, 113. But it is, the point is that when this 113 has been added, so it's a parallel to the UAPA, Unlawful Activities Prevention Act. Earlier, for invoking UAPA, there was a requirement for getting permission from the Superintendent of Police rank of officer. Only then UAPA could have been invoked. But with this 113 BNS, same offense can be leveled against a person. But the point is that earlier UAPA also was rigorous as far as the presumption of innocence is concerned, and also the right of bail. So the restrictions which were there with the UAPA, now by putting 113 terrorism, the accused would have benefit which were not there, the bail benefit which was not there available to him in UAPA, and the benefit of innocence. So that's also there when it comes within IPC. So the rigors of UAPA are also, he can have better, because their UAPA, the bail was only if it is the court is prima facie of the view that accused has not committed the offense. But this condition is no more there when it is 113 of the BNS. And then Bharatiya Nagrik Sanhita, that is the amended version of CRPC. It's also like majorly what the statement of reasons and object had said, that it has been introduced with the view to include forensic sciences. Lastly, it was amended in 1973, and section 176 of BNSS corresponds to 157 of CRPC. The forensic experts are required to visit the scene of crime and collect the forensic evidence. But there is also a caveat has been created, because as of now, so many forensic experts are not available. So for 5 years from introducing this law, amended version, and for the coming 5 years, this investigation through the forensic expert, that room has been left there for 5 years. It will not be a mandatory thing. Timelines have been fixed. Timeline for registration of FIR, timeline for medical experts to give the in the rape cases to give their medical report about the victim, and then medical examination of the witness, and for how much time the committal has to be completed. And also the judgment, the timeline has also been fixed for the judgments to be delivered within 30 days of the conclusion of the arguments, or maximum 45 days. And so that's like something positive which has been added. These timelines were not there in the BNSS. And the point which can be of concern, that digital devices, court can now compel the production of communication devices likely to contain the digital devices. And my personal experience says that as far as this technology is concerned, there can never be a full stop to the technology, because technology each and every day it is getting changed, or it is getting improved. So it will be very difficult for law to follow the technology. As far as the interjection of wherever there is technology involved, to crack that or to bypass that will be certainly very difficult. But it's a good movement. It's a good step forward that technology, there is a reliance on the forensic and technology, because in a rape case, if the forensic is done properly, then there is nothing more is required. So forensic is very important. It is a scientific investigation. The challenge only is that we do not have that much of manpower and that much of intelligent manpower who can truly do justice with the forensic investigation. And then police custody, which was referred by Mr. Hegde, it is it still continues to be 15 days, but that 15 days period has been scattered. Like in the initial 40 to 60 days period, if the challan has to be filed within 60 or 90 days, so in the initial 40 to 60 days period, if the person continues to be in custody, if he is released on bail, okay, that 15 days will not be made applicable. But if he continues to be in custody, then this 15 days can be scattered. But the custody remains, the upper limit of which was earlier there, 15 days, is still there. And then there are also points which take care of victims' rights. This BNSS regarding victims' rights, the BNSS maintains that the police must inform the victim about the status of the investigation within the 90 days as to how the investigation is progressing. The victim has to be informed about that. And if the police has to, the prosecution has to withdraw any case, which was earlier not there, the victim has to be heard, the complainant has to be heard. That is also provided under BNSS. And again, the statement of object and reason of Bharatiya Sakshya Adhiniyam, that is Indian Evidence Act, also is on the same lines, that the point is to speed up the trial and to minimize the time spent on admission and denial of the evidence. So that is one thing. And as far as this Maharashtra Special Public Security Act, which is also called as Urban Naxal Act, it is only in the statement of reason and object that urban Naxal word has been used, but in the entire definition, in the entire act, this word has not been referred to again. But similar kind of laws are already there in place, like Chhattisgarh has the Vishesh Jan Suraksha Adhiniyam of 2005, Andhra Pradesh has a Special Public Security Act of 1992, and Jammu and Kashmir has the Public Safety Act of 1978. Urban Naxalism, as the name itself means, because Naxalism per se is specific to a particular jurisdiction or the tribal or the village rural people. So the intention of the law is to ensure the public safety, and it is already there in 3 other states. I am not commenting on the Broadcasting Service Regulation Bill, because as it is there in the public domain, that it has been withdrawn by the government.
Thank you, ma'am. Mr. Sengupta needs no introduction, and I'm sure he'll enlighten us about everything that has been said, enlighten us further.
Thank you very much, Manish. I think since we are having this discussion in the context of the horrific rape and murder of the doctor in Calcutta, it struck me yesterday that when 2 doctors were summoned by the police, Kunal Sarkar and Shubharno Goswami were summoned by the police in Calcutta for putting up some social media posts. And there was no ground that was alleged on why they were summoned. There was no section that was quoted. And according to one of the doctors, when they were called there, the police said, "Oh, don't bother about the summons. We're just here to have a chat." Now, I don't think it's anyone's idea of spending an evening out, of having a chat with a police officer. But I think it really brought home the fact that very little has changed on the ground with a change in these 3 legislations. The fact is that the police has as much power as before, in some cases more, as has been pointed out by Mr. Hegde, in some cases slightly less. But the procedures remain the same. The laws, 80% of these 3 laws are exactly the same as they were in the IPC, the CRPC, and the Evidence Act. So they are exactly replicating what was a colonial legislation while saying that this is an attempt to decolonize it. So very little has actually changed in terms of how the police is going to behave. And so the fact is that what we are discussing here, I think Mr. Hegde in his characteristic style called it the Modi Code. I don't think it's the Modi Code. I don't think it's certainly not the Macaulay Code as well, but it's just a mediocre code, which I think that there is much to be said here, and I'm going to talk about a few of the items that I think have significant effects for media freedom. First, let us look at the 3 provisions that were used mostly against the media. 153B that was used for promoting enmity between groups. 295, that was used if you offended somebody's sentiment, particularly relating to religion, or 292 to 294, which dealt with obscenity. All these provisions remain on the books, so they remain exactly the same. Now, as far as the provision on sedition is concerned, and Ms. Kalra referred to that provision, she's right in the fact that they have removed the word government. So it appears to be that it's offences against the state, but not offences against the government. But if you look at the if you read the text carefully, one of the words that is used is subversive activities. And subversive activities by definition is activities that are done against a government. So it has kind of, it remains really in kind of, at the end of the day, a leopard can't change its spots. So it's really not changed the substance of the provision very much. What it's also done is that there are several undefined terms that have been brought in, like the word financial means, like the word subversive activities. These are all terms that are not defined in that legislation. So currently it's not clear as to what it means. I go back to another provision, and if you remember, I mean, there are many in the audience who would know this firsthand, as in I was all of 5 years old at that point of time. In 1988, Rajiv Gandhi had introduced the Anti-Defamation Bill. This was during the Bofors scandal, and it was withdrawn after severe protests, but it had several of these kinds of provisions that are now present in the three Sanhitas that we are talking about, including this idea of the zero FIR, which is that an FIR could be filed according to the 1988 bill, an FIR could be filed in any court in any part of the country, and an editor would have to personally appear there. So this was a provision that was there in that provision in the 1988 Anti-Defamation Bill. As far as the current code is concerned, the provision of the zero FIR, if I were to look at it from the perspective of a journalist, is hugely problematic, because the idea of a zero FIR came in the context of a judgment given by a court, where it said that if there's a rape victim who has come to a police station, the policeman or woman shouldn't send her away, saying that it is not within the jurisdiction of the station, saying that register the FIR and investigate it. But now it has been given statutory footing that it can happen for any offense in the country, in any court. So if we were to continue this Itanagar example, because it can get a little bit more problematic than what he said, the Itanagar court can register it, and not can register it, has to register it, number one. Number two, when it has to transfer this case to Delhi, suppose it is an action that has happened in Delhi, when it has to transfer the case to Delhi is not made clear in the statute itself. Now, the BPRND has put out some instructions saying that the transfer must happen, but at least in the statute itself, it is not clear as to when the transfer must happen. Second, it's also not clear whether they can do any preliminary investigation or not. So can they do a preliminary investigation? Can they do an arrest on that basis? This is not clear as far as the text of the statute is concerned. So as he has said rightly, that we will await judgments on this to see as to what the safeguards that can be built in, what these safeguards can be. But till that point of time, as in, it remains potentially problematic. But overall, and this is my larger point as far as the code is concerned, and the three codes actually, given the fact that one, as I've said, 80% of the codes remain the same. A lot of the changes that have been made in the other parts are problematic, but were kind of vestiges of the IPC itself. This is actually a larger issue. This is a larger issue of a state and its citizens, and what that interrelationship is. And as I've said both in my book and elsewhere, that the Indian state is one that has always towered over the citizen. It has always been one that has significant amounts of police power, even as uncomfortable as it may be for many in this room, even in the Constitution, where our fundamental rights chapter has a provision on preventive detention that legitimizes preventive detention of individuals without charge or FIR. Now, there is a history of police power that exists in our legal framework. So just as in 1947, 1950, when the Constitution was drafted, changing the name of the police force from the Imperial Police Service to the Indian Police Service didn't really change the way in which the police functioned. Similarly, changing the laws today from the IPC to the Bharatiya Nyaya Sanhita will not change the way in which police functions. And I think it's going to remain much the same in terms of the actual power that it wields, and that is made quite clear by what's happening in Calcutta today. Because at the end of the day, the debate that we are having is a very similar one to the debate that we might have been having before the Sanhitas came into existence. So this is as chilling for media freedom as the Indian Penal Code was. In certain cases, it is more chilling, and that is why we must frame this as an issue where the citizen must continue to struggle against the state and unbridled state power. So just to end on a more optimistic note, as in the anti-defamation bill was withdrawn after 2 months of protests, the broadcasting bill also has been withdrawn, after, or seemingly withdrawn, as Paranjoy pointed out, but it seems by all accounts that it has been withdrawn. So this obviously has now become the law. It cannot be withdrawn, but a new law is only a beginning. We have to make sure, as Mr. Hegde pointed out, that this is not the end and that its problematic provisions are the sites of struggles by citizens to ensure that the state does not continue to enjoy unbridled power. I'll leave it there.
Thank you, Arghya. Akash, and if you could, tell us something about your idea of whether this broadcaster's bill is actually dead, or is it dead and alive?
By habit, have to take a contrary position here also. No, not dead. It's just the draft that has been withdrawn, the second draft. And I'll explain why I don't think it's dead. So I think you've heard a lot about the BNS. I want to only focus on broadcast and the broadcast bill and why the government is very, very worried about the rise of digital broadcast. And I don't think that they're going to rest just because there has been a little protest and their bill details, their draft has been leaked. You have to understand how India's media landscape is shaping up. I have been part of print. I was part of digital. I was part of mainstream media. Not very proud of it. I've been part of mainstream media for about 10 years. I've worked with some doyens of mainstream media. I don't want to name them anymore. I feel ashamed. After having seen what has happened with print, because the government can literally, not many people know about 40% of revenues of traditional print media comes from government ads. Without that, they'll just... So how much can you go and criticize the government, which is giving you 40% of your revenues? Television, the same thing. The kind of licenses, the kind of uplinking, downlinking, advertising revenue, it requires crores and crores per day to run a news channel. It is not a joke. And again, there could be so many loopholes. And so you'll eventually have to bend before the forces. So the going was pretty good till recently. Print in my control, television in my control, the national narrative in my control, and there would be few dogs on digital that would be barking. And literally we've got comments, yaar, tum log bhaukte raho, kuch nahi hone wala hai. And I'm like, yaar, bhaukne do na yaar, kya problem hai fir yaar? Let a few dogs bark, what's the problem? I think what has happened post 4th of June is the serious realization that these dogs are not barking, they are biting at this point of time. And that bite has been felt. Now, a lot of people say, "Acha, dekho, tum log ne to result change kara diya." I don't think so. Result koi change nahi hua hai. Let's not forget, there was a very clear division as far as voting patterns were concerned. Urban areas versus rural areas. Let's understand where they suffered. The government suffered as far as the rural areas is concerned, not the urban YouTube watching urban class. But it so turns out that no, actually there is a lot of YouTube consumption that's happening in the hinterlands also, because you get to see these reports and you get to see these comments and mails, etc., etc. What digital independent content creators, however, did manage, and there's no debate over that, is they managed to challenge the narrative that was being pushed out day in, day out by the Godi media. And when you challenge that mainstream narrative, you allow other people also the idea, okay, these guys might be lying. These guys might be feeding us propaganda. Let's question a few things. And that is what singularly a couple of online platforms, websites, content creators manage to do is the thousands of crores that has been poured over on traditional media to challenge that narrative. For the first time in 10 years, you saw that narrative slipping. And of course, post 4th of June, I don't know why, suddenly what we were saying for the last 6 years on the Deshbhakt is suddenly valid now. What were we saying? That don't go for any one party. All parties are chores, some less, some more, question every party. And, if you really want to have a book to follow by, go by the Constitution of India. So suddenly that idea is now gaining traction and people are starting to question. And therefore, I believe that the government is not going to just let digital media thrive and let people question and put facts out. That's not how, as was being pointed out, that once you get the taste of absolute power, you don't want to let go of absolute power. So what has happened, and this is very interesting, is the government first circulated the first draft of the Digital Broadcast Bill. It was a public consultation draft. Everybody had access to it, everybody saw it, everybody could comment on it. That's usually what happens in a democracy. I know, sometimes these days when we look at parliament and, opposition shouting, suddenly people are saying, oh, ye arajakta phail gayi hai. Because for 10 years, they haven't seen how a democracy works. Yes, it is a little loud and rancorous and, it has a little bit of shouting. That's absolutely okay. Bills come, bills go, bills are retracted. People who have started following democracy for the last 5-8 years don't know that. So what happened is the first draft then got shafted. Government got busy with the elections and everything was okay. And then suddenly after 4th of June, the realization that no, this has to be taken care of. And you have the second draft of the broadcast bill. And why it is important to discuss it is because see the nefarious means with which the draft has been circulated with watermarked copies given to select media houses. So I can't exactly tell you with authority. Maybe there'll be a case against me if I talk about this right now, because when we were making an episode, we were like, can we talk about this? Because, well, we don't have the draft. But the government said, no, I'm giving you physical copies. This is watermarked. You can't discuss it with anybody else and you give it back to me. But, I mean, we are a nation of leaks, man. We are talking about NEET exam leak ho jata hai. You're talking about a bill leak, draft leak nahi hoga. Leak ho gaya. So what do we get to know from media organizations and those who have seen the draft? Government can shut down any channel, obviously. National security, public order. Please understand, this is a threat to public order at this point of time. So tomorrow my channel, I'm not joking here, tomorrow my channel can be shut down based on the fact that I gave a talk which might be to public order, danger to public order. That is where we are standing at this point of time. And this is not a joke. There are channel 1 in Kerala already suffered this. National security. National security could be anything. National security doesn't mean the border is being infringed or India is being divided. National security could be anything. So please understand, in this nation, we have forgotten to divide the government and the nation. The government has become the nation. Until the general perception of the people is the government is the nation, these things will pass by. Very interestingly, the government said, how do I control so many content creators? So allegedly, in this draft, there is a provision for professional content creators. Those content creators who will, on a regular basis, on a sustained basis, in a systematic basis, I'm not joking, these are the words, produce content. They will be put at power and their requirement and compliances would be at the level of an Amazon Prime, all the OTT platforms of the world. So imagine somebody's running a YouTube channel with 3 people. He has to now have compliances what Amazon HBO has to have. This is the kind of broadcast that is being talked about. And of course, grievance redressal, that anybody can just ask me that, no, I'm not happy with your content. You have to reply to me within 24 hours. Imagine a YouTube channel of 3 people suddenly being deluged with this. So very, very important to understand that this is being just withdrawn. This will come back again, and we as conscious citizens need to really push back against it. If there is a pushback, then of course we will see some sort of holding back. Yes, we've seen some sort of holding back. We've seen some of the government taking a step back, and I honestly think that this is just democracy reasserting itself at this point of time. But that means you and I all have to really speak up.
Thank you, Akash. We are actually running out of time, so quick rebuttals, 1 minute each, starting from Paranjoy and ending with Arghya.
Just a few points to add to what Jyotika ji just said. When these bills were passed in the Lok Sabha and the Rajya Sabha, how many opposition MPs were disqualified and out? Just check the facts. 150 and 100, if I'm not mistaken, in the different houses of parliament. Question number 2. The debate about Article 19.2 is many, many decades old. Who decides what is a reasonable restriction on the right to free speech? Is it your local goon? Is it your thanedar? Is it the Inspector General of Police? Is it your magistrate? Is it the Chief Justice of India? The deliberately giving this vague, reasonable, the word reasonable for whom? This is a problem area. It has been a problem, remains a problem. One thing that we have not talked about is the issue of surveillance and privacy. I know because I'm a petitioner. I believe my phone has Pegasus in it. I kept it there, but anyway, they're listening to it. But it's been 2 years. It's been 2 years since the then Chief Justice of India was given a thick report about another committee that was set up under the leadership of a retired judge of the Supreme Court. We don't know what it contains. We've been waiting. It's been coming up for listing every now and then. Nothing has happened. We don't know. The Solicitor General of India, when he was asked a straight question by the then Chief Justice of India, please tell us whether or not any agency of the Government of India has purchased Pegasus or not. Say yes or no. He said, my lord, I cannot answer your question. National security is at stake. I mean, I'm just giving you facts again. Today we are in a situation where this teenager called the RTI, the Right to Information Act, is in a mess because there's a 100-year-old OSA, the Official Secrets Act, which is prevailing. 2 last points. This whole issue of public order. Who decides public order? In the NewsClick case, in the UAPA case, there were at least 400 police personnel who were asked to assemble at 2 o'clock in the morning. They fanned out to 80 different locations in the National Capital Region to arrive there at 6:30 in the morning alarm service. Again, never happened in this country before. I could completely agree with what Akash has just said. Deshbhakt is correct. This business about mobile phones being used in urban areas, small towns. No, it's all over. In most parts of India, there are more SIMs, SIM, subscriber identity modules, than human beings. I'm not saying so. We are supposed to have 1.4 billion people. Go to the website of the Telecom Regulatory Authority of India and you'll know that there are over 1.1 SIMs or subscribers. Last point, half a minute, less than half a minute, 15 seconds. Every now and then we keep hearing about the convergence bill. We're supposed to have the government coming into, realizing this print, radio, television, internet, they all, you need whatever governance you need, right, wrong, good, bad, self-regulatory, not. You need one body. The late Sushma Swaraj used to say that every time the talk about a convergence bill comes up, the government collapses. So we are waiting for this government to talk about the convergence bill again. Thank you.
Thank you, Mr. Guha. Ma'am?
Rebuttal to Mr. Paranjoy?
No, you can rebut to anything, including the laws.
Okay. I'm only insisting on Article 19.2, which gives the powers to the state to impose reasonable restrictions. And again, the subjects on the basis of which this reasonable restrictions can be imposed are interest of the sovereignty and integrity of India, the security of the state, friendly relations with foreign states, public order, decency or morality, or in relation to contempt of court, defamation or incitement to an offense. So the Constitution gives the power to the state to enact laws to restrict freedom of speech in favor of all these subjects or all these areas. That's all.
Akash?
I'll just make another point since, sometimes what happens is people who are conscious, aware of the knowledge, we choose silence. If I was to say what do I appreciate most about trolls, because I deal with them on a daily basis, I appreciate the mindless unity that they have. Sometimes it's okay not to use so much of your agency also. there is one larger aim, and everybody is attracted to that one larger aim. What happens with progressive thought process is, because you are thinking and you have your logical faculties, it gets split in many directions. But the larger aim at the end of the day is the nation, the constitution, the freedom of speech, and the media. And I wish that there was a little bit more convergence on that. Why I'm addressing this to you is because you will see this in the coming days a lot more. The return to the Indira Gandhi principle, which is external agencies. I have started to see this a lot more on social media at this point of time. Earlier it was about being a Congress and an APTAD and a CONCTAD, and now it is about Soros. It is about the latest at this point of time, because I went and addressed, I had a social media talk at American Library. I am a CIA asset at this point of time, ladies and gentlemen. So you're talking to a CIA deep state asset at this point of time. Now, it might sound funny, but I don't take it funny anymore, because I took it funny at the time when a flop director called Vivek Agnihotri launched a concept called an urban Naxal. And now that same shameful, idiotic terminology that has no sense whatsoever is used in legislation. So what happens is, this is priming people. Oh, ye to udhar ka hai, ye udhar ka hai. And then the law will strike down. Please be aware of this, that you're not calling yourself anti-national, arey hum to anti-national hai. That is basically priming people. That, he wants to spread anarchy. So my request to you, besides the bill, be aware of, when you run out of excuses, you're looking for an external enemy. At this point of time, I'm telling you with the way, today's report, 70,000 crores worth of car inventory has piled up. Anybody who knows basic economics will tell you what is that signaling for in the next few months. So please be aware that now more of this pointing, blaming, and then the law striking will happen.
Thank you. Sanjay?
No, as Akash was speaking, I was reminded of an old incident. And since Akash is wearing a T-shirt, and he always wears T-shirts, in the old days, there was this talk of being a CIA agent. It was the late Pilu Modi who turned up in Parliament with a T-shirt saying, "I am a CIA agent." So I think there is a market. Tejinder Singh Bagga, to please note that, a photograph of Soros, I am his agent or something of that kind.
He's stopped the T-shirt business. He's selling biryani now.
And
Don't
Akash
tell
is
me.
not allowed into the IIC lounge.
Okay. Don't tell me that he's selling veg biryani. Okay. No, I have been known on social media for talking about veg biryani. And the point is, one of the ways, and the most ways of subverting a bad idea is to laugh at it. The freedom to laugh is intrinsic to our freedoms. And so it happened that Mr. L.K. Advani spoke of the Charare Sharif, and that the Supreme Court has ordered biryani to be issued to the terrorists. It was Ujjwal Nikam who took it further when he said Ajmal Kasab wants biryani. And so therefore the question came, what about veg biryani? And once you look at it from that perspective of laughter, and so today veg biryani has become the one issue on which you can debate passionately, and it's across party lines and everything, and nobody has yet invoked a samhita against it. So the freedom to laugh, the freedom to look at their pomposity. Today they are at 240. Please look at when these samhitas were conceived and passed. And if they had come 400 par, I bet this function would not have been held.
Sir, can I ask you a question?
Sir, we'll take the questions later. Arghya?
Usually at the IIC, I actually feel quite young, but suddenly following three people who are so active on social media, I'm feeling very old because I'm not. But so I'm going to take it back to a slightly old-fashioned discussion of one point that I've been hearing throughout, which is that one of undefined terms, right? Reasonable restriction, we don't know what it means. All the terms, whether you're talking about sovereignty, what is national security, and so on. Now, I think as a constitutional lawyer, this really should not have been an issue, because these terms should have had clear meanings that are given by the Supreme Court, which are followed by all courts in the country. So it really should not have been a problem. What this shows, and this is a point where I slightly differ with Mr. Hegde, is the fact that people are also losing faith in the judicial system to be the messiah of all our ills. And I think that there has been a lot of weekend pontification by justices of the Supreme Court, where they are upholders of civil liberties, but only on Saturdays and Sundays. And this has become a very common phenomenon and an irritating phenomenon. Because the fact is that, and I think that as a person who believes that in some amount of judicial restraint, I think that in some senses this is good, because ultimately, if this Samhita is going to go, as in it is going to go through severe public protest and condemnation. It has to go through politics. It is not going to go through courts provision by provision. It might help. But the fact is that this fact of undefined terms is really showing to me that we are slowly but surely losing confidence in judges, in being upholders of our civil liberty. And the second point on 19.2, and I think this, since I want to go back to my pet theme, and I'll end with this, that this is really an issue of the state versus the citizen, which is an issue that has long predated Modi and the BJP. And that is really, we are talking about Article 19.2, which is the basis of all restrictions on free speech, from which every single legislation that tackles free speech, whether it be defamation, sedition, contempt of court, etc., all of which this is the mothership. And that wasn't the original provision in the Constitution, as we all know. That was brought in through the First Amendment of the Constitution to stop certain publications by the Nehru government. And that was done by the same Constituent Assembly, sitting as the first Parliament of India, that authorized Parliament to pass laws that could stop that could stop speech for being seditious or being contemptuous or being defamatory and so on. These were not the restrictions in the original Constitution. So in India, right from 1950 to 2024, in varying degrees, admittedly, but this has always been an issue of the state versus the citizen. And like Akash said, I think it's time for citizens to stand up and be counted.
Thank you. We have time for some short questions. Kindly raise your hand, identify yourself, and just questions. No commentary. Thank you. Yeah, please. Can we have the mic here?
Hi Akash, I'm Rajas. I'm presently a LAMP fellow. I would like to ask you a question regarding self-censorship. As someone who works in digital media right now, I believe there must be a degree of self-censorship that you do engage in. And as you spoke about the digital broadcasting bill, do you think this is something that will lead to an era of McCarthyism in India? Or do you think, how much worse do you think this self-censorship will get for you as a creator?
So, I don't. There would be some creators who might just say that, nahi, nahi, hum to sab bolte hain. I think any creator who tells you today that, no, they don't do any self-censorship is brazenly lying to you. Huge amount of self-censorship. Every line that we think about, every action, every tweet that you put out. Remember, there is a fact checker who went to jail, not because of fact checking, because of a satirical post. It wasn't any sort of news publication fact checking. It was a satirical post 4 years ago of a 30-year-old movie. So anything is game at this point of time, right? If the powers that we want. So huge amount. Not only newspapers and television, that is though by compulsion, but for digital publishers, it is, you see, for a small digital publication, either I can run a channel or I can go to court. I can't do both. So if I'm going to go to court, which we are ready, but then I will not be able to do what I do efficiently here. So obviously you only choose to fight the fight you want to fight. So you have immense amount of self-censorship. What the digital broadcast bill will do, and eventually it will come, is basically you won't need the BNS that we are talking about. Because wo to after hai na, after done. What do you do as a smart government? You don't have to come to BNS. You will ensure that there is chilling and there is shutting down of any sort of mischievous voices. And that is exactly what this bill aims for.
Yeah.
If I
Any
can
more
just
questions?
add one line.
Of course, sir.
I'm reminded of what the late lamented Idi Amin Dada said.
Yes.
Freedom of speech is guaranteed, but freedom after speech I can't guarantee. Some
Yeah.
wives also follow that principle.
Yeah, please.
Hi, a question for Sanjay and Arghya both. I'm sorry I came a little bit late, but I believe Paranjoy spoke about search and seizure of devices. Could you comment a little bit on how that gets impacted under the law? And, just purely from a fundamental right to privacy perspective, are we seeing the implementation of necessity and proportionality expectations in the way both the BNS deal with it, plus also from a journalistic exemptions perspective, the data protection bill also doesn't give us those exemptions. So just wanted to check about about protecting sources under the current sort of changes in law.
So as far as the search and seizure provision in the BNS is concerned, I think there is a case that it violates the fundamental right to privacy under the Constitution. I think that's the short answer. We can have a separate discussion on that. As far as the data protection bill is concerned, I must say that the first draft that was done by Justice Sri Krishna had a journalistic exemption. I should add that. But the journalistic exemption doesn't exist. So at this point of time, journalists have to get covered by legitimate use in some shape or form. That in my view is the only way that it can get covered. But otherwise, yes, as in the fact is that protecting the privacy of your sources is not guaranteed to journalists under the Personal Data Protection Act.
The other thing is that the provisions in the BNS are checked. They can seize your devices. There's no provision for return.
Yeah. Anybody else? Yeah, please. No, all of us are laymen, sir. Only these people are experts.
But I don't understand the need to revise the old act to new act. The basic idea for revising the new act is to give more power to the people. Because that time you were gulams, so laws are made to deal with the gulams only. But now this new act become more harsher. I don't understand.
So, who wants to take this?
Well, you see, freedom is what the citizens make of it. You said that time we were gulams. Are we less gulams today? I have my doubts. And sometimes I think that the progress over the last 200 years has been from the East India Company to the West India Companies.
My name is Rajesh Mahapatra. I have a question, maybe a little unrelated to what we are discussing today, but in some ways related also. So for this past week, it so happens that I'm revisiting the cases filed against journalists during COVID. Now, I saw a pattern that after the Supreme Court started, passing orders to restrain, there was a significant drop in the kind of cases that got filed. But even by then, more than 100 cases had been filed. And in all cases, which went up to High Court or Supreme Court, the ruling in most cases was they asked the police to show restraint and not act against the journalists. But in most cases, they did not quash the FIRs. So the FIRs have not been quashed in many of these cases. And I started speaking to some of these people against whom these FIRs were not quashed, but restraint orders were given. Now they also are clueless because they have also forgotten about it. They have moved on with life. What happens now? Because is there, a possibility that at any given point in time, some of these FIRs can be revived?
Well, the FIRs are alive. An investigation can be done. Does an investigation end up in a charge sheet or not? That's the question. Most police departments don't really bother about the FIR. But if somebody is minded to so do, He can always complete the investigation, present a charge sheet to court, and then take the matter further. Yes, yes.
Journalists are actually in small towns, small villages, without much resources or counsel. Is there a scope for a collective action to do something about it?
Collective actions will
I
not.
mean, is there a way that you could go to the top court and say that, now can you just quash them at,
No. They see the point is that the law operates on a series of facts. Now, specific fact. Okay, this FIR in Jalgaon, it falls within the parameters laid down in Bhajanlal's case. Therefore, quash it, etc., etc., etc. That has to happen case by case, and the Supreme Court is averse to these mass burials. An administration can very well do it. A Home Secretary can say that all these things which are pending and which clog up the system, I close all of them. But courts are not administrators, or at least they do not pretend to be.
Sir.
A related question. Is there a law of limitation under the new, these new statutes?
Good question. I think the same CRPC provisions.
So the FIRs can continue indefinitely. Is that
No.
the implication?
The limitation, no FIRs have actually been quashed on limitation alone. FIRs will continue. Investigation may or may not happen unless your opponent decides to put things in motion and say there is this FIR. Tell them to either conclude the proceedings and file a B report which closes proceedings, or file a charge sheet.
Yeah.
Just
Please.
tell them.
आपके पीछे.
Just taking off from the question the previous person asked about collective action, is it not possible to have collective action on impounding devices of journalists? Like 80 journalists, their devices are still not back with them. So in that kind of case, is it not possible to have a collective sort of call from the from the Supreme Court?
And everything is conceivably possible, but it is a rare court which actually does it. There is class action
But you are
in one
saying
sense.
it is possible. So you are giving us hope that we could go with a petition to the Supreme Court and say that return
Every matter
these.
does not have to travel straight to the Supreme Court. And often, the first thing that many lawyers in the Supreme Court, or good lawyers, do is we follow the Hippocratic principle. First, do no harm. Because if the Supreme Court were to say no, then no other court can say yes. So if you have a documented set of facts about all the devices which were seized in Delhi, for instance, go to the Delhi High Court. Say that they were seized in this particular case. The investigation is over. A charge sheet has been filed. It doesn't appear that these devices are wanted. Tell them to return it. That is a possibility.
So Sanjay, I'm so sorry,
Oh, of
Manish.
course, ma'am.
What if I have a naughty question here? How do we get the Supreme Court to take suo moto interest in this question of seizure of devices of journalists? Is it possible? You needn't answer it.
Do you want me to answer this?
Yeah, answer.
Please go ahead.
So
He has much greater knowledge of the Supreme Court.
So-
Because I may know the law, he knows the judges.
So, ma'am, the short answer is that many years ago, all of you might have heard about NJAC, the bill that was brought in to change the collegium system. In this time and age, if this government was somehow get the parliament to pass the NJC again, there is no court, including the Supreme Court, which to my mind will stay it. Arghya appeared in that matter. I think Sanjay also appeared in that matter. Stay नहीं मिलेगा आप लोगों को. If you are talking about going to the Supreme Court as a collective to get your phones back, it'll by the time the phones you actually get them back, your phones would have run out of their life cycle. You know, that is why people, I think many people like me, who have followed the courts and who have very high respect for the courts, we seem to be losing faith in the courts. Because as somebody said, that our judges are busy, the other day the tweet went viral, lecturer in chief. So this is, unfortunately, this is the truth. This is what the reality is. So, yeah, please.
Hello everyone. I am Ahmed. I am a law student currently. So my question is to Akash sir. Sir, like, as of now, like, there are 4 pillars, and one of this, the media is considered as a 4th pillar of a democracy. And like in these days today, like whenever I see media, like the TV channels, what I feel is it has left no value as it was having earlier. So what environment can we provide, or should the government provide to rebuild that pillar, to strengthen the pillar as it was very earlier, to strengthen the democracy?
You're a law student.
Yeah.
So, ये मेरा pet सवाल है, my pet peeve. ये 4th pillar वाला कौन सा उसमें Constitution के book में लिखा है? 4th pillar वाला. Which provision?
It is not written anywhere.
So, lot of times, lot of people get very, this thing. Common people think that हम जो 4th pillar बोलते हैं, so that means that there are constitutional provisions, there are safeguards, there are benefits that, I'm telling you, so many people have said this to me. So they get very shocked to know that journalists have zero safeguards, there are no provisions whatsoever, and it's only because of some judgments of the Supreme Court that even jo hai, wo hai. See, any government, and this has been pointed out also, Rajiv Gandhi's example was being taken, any government is not interested in building your 4th pillar. Let's be very clear about it, okay? BJP, Congress, we've seen the regional parties also, sometimes they're worse off. So then who's going to take care of this 4th pillar? What we have seen in the last few years is that people are gradually realizing कि हाँ यार ये जो television पे दिखा रहे हैं ये तो एकदम कूड़ा करकट है. It is, I mean, if you would have told me 5 years ago that ये जो top television journalists हैं इनको रास्ते पे they will be hooted और इनको भागना पड़ेगा रास्ते से, I would have laughed at it. लेकिन आजकल हो रहा है. These guys, I know of senior television editors who travel with security. I am not joking. They have security, black dress, like maybe they are not black cat commandos or something, but they have security. Why? Why are they traveling with security? That some mafia is going to kill them? No, they are traveling with security because आप और हम में से ही उनको डर लगता है. So let's be very clear that what will happen of this 4th pillar is when people will say, ये तो आप हमें गधा बना रहे हो, ये पत्रकारिता नहीं है. And what has happened is that digital space has opened up where people are now taking recourse कि अच्छा, if I want to see what is happening in the country, I will watch a few people, I will watch this website, I will watch this creator, which any government is not going to be happy about, by the way. So I don't think anybody is going to build the 4th pillar. It is you and I who will have to support good journalism, who will have to support good content creators, who will have to not watch television. Please remember, a lot of us in this room would also be guilty. नहीं, वो तो हम fun के लिए देखते हैं. But that is what they want. They want you to watch for that 1 or 2 minutes. They get their TRP numbers out of that. Stop watching bad content, watch good content. That's your 4th pillar.
Can I add to what you said? Like you, young man, my son is aspiring to be a lawyer. He's studying to be a lawyer. If there is one organization or estate which has been responsible for the weakening of the so-called 4th estate, it is the government. To expect the government to strengthen the 4th estate, you might as well live in a dream world. I want to add something to what Rajesh said. Rajesh, you were talking about Rajesh Mahapatra about COVID.
Rajesh is a journalist and he was with the Hindustan Times earlier.
So Rajesh, on the COVID matter, suppose I'm just a hypothetical question. Suppose I move a petition saying the Solicitor General of India lied to the Supreme Court of India on the 31st of March 2020 when he quoted the Home Secretary of India saying there's not a single Pravasi Mazdoor, there is not a single migrant on the highways of India. Suppose I accuse the Home Secretary and the Solicitor General of lying to the Supreme Court. What do you think would happen to my petition? Would it meet the same fate as Lokpal former judge of the Supreme Court, Justice Khanwilkar, when he was said, the government should inquire because the Prime Minister has said, Rahul Gandhi is getting tempo loads of cash from Ambani and Adani. Why don't you inquire it? And so Justice Khanwilkar says, no, these are said in the heat of or electioneering, propaganda, campaigning, etc. एक सवाल मैं संजय जी से पूछ सकता हूँ? Sir, why do you think the one comedian, you were talking about comedians, by the name of Sham Rangila, why did he fail to stand for election from Varanasi?
That you could ask Mr. Rajiv Kumar that, the CEC. The point is that if the government of the day were determined to do a particular course of action, the only institution that has the power to stop them is the judiciary. But the judiciary often is sometimes more executive-minded than the executive itself. I think that there are not enough mavericks in the judiciary. They're all good boys. They're all good government lawyers and pro-government lawyers who normally make the cut. I might get into trouble for saying this, but sometimes it's like this, that the army stands for the nation at the borders against foreign governments. But the institution that the Constitution has charged with defending the citizen within the borders is the judiciary. And if your army does not fight, what happens to the nation?
So we'll have one last question. The lady in the middle.
I'm sorry.
Thank you so much for the insights, and we are very happy that 4th June was a relief. We can happy for the next 5 years. So the question is like this BNS, I do not think is there any need for this thing, but still they have made it. So does it have any impacts on personal laws or like religious things and the things we personally do, like some wear hijab, somewhere do this and that. So does it have impacts on these things as well?
I don't think so. As far as personal laws are concerned, the BNS is neutral on all that. It can be equally offensive to all people of all religions.
I'm coming to you, ma'am.
Yeah, I'm with you. Hi, my name is Anvita. I'm a LAM fellow, and my question is to Mr. Hegde. So this question might be slightly technical. Given the fact that about 30% of those under preventive detention are Muslims, and around the same percentage of those under trials are SCs and STs, do you think that in this effort of decolonization, we missed an opportunity in providing safeguards to these communities from such targeted profiling?
Well, I mean, we missed several opportunities. Firstly, I don't think we needed this opportunity. We shouldn't have gone into all this BNS anyway. And I sometimes think all this is, the N is silent in BNS. But the point is, whether it's Muslims, tribals, scheduled castes, the law always works its mischief much more on the underprivileged and the poorer than it falls on the, then it operates on the rich. So yes, we did miss an opportunity to strengthen legal aid, to have public defenders. Every little liberty that the courts had brought in over the last 75 years, most of them have been identified and quietly tucked away somewhere or the other. So yes, we did miss quite a few opportunities. I think that, yeah.
Just one line, I just want to add. You already know it's a statistical fact, 80% of it is the same, right? The BNS is N silent or not N silent, it's the same. So then you have to ask yourself, what was the crying need to change the 20%? What was the requirement, and then to sell it as decolonization? You know, a lawyer was telling me, it's so funny, things like horse carriage, telegraph, telegram is still in the new BNS. So what are you talking about? You've cut copied 80%, and then obviously, I mean, it doesn't require rocket science knowledge to know why the 20% has been changed and why it has been tweaked for the public or for the government.
Ma'am, this is absolutely the last question.
हो सकता है आज के सब्जेक्ट से डायरेक्ट मेरा क्वेश्चन जुड़ा हुआ नहीं हो, पर ये एडवर्टाइज़र और एडवर्टाइजिंग एजेंसी से जुड़ा हुआ है. केबल है या कोई भी एडवर्टाइजमेंट है, कहीं तो आप ब्लॉक करके उसको रोक सकते हैं, पर आप ये देखेंगे कि जिनको एडवर्टाइजिंग का अधिकार और पैसा मिल गया है वो एडवर्टाइजमेंट लगा तो देंगे, चाहे केबल के रूप में हो, तारों के रूप में, बट हटाने की जैसे उनकी कोई पॉलिसी नहीं है.
वो
ये इसलिए मैंने कहा आज कानून के लोग बैठे हैं, शायद उसका कोई जवाब देंगे.
इसके बाद जब बाहर खड़े होंगे आपका इस सवाल का, इनसे पकड़ के जवाब लिया जाएगा.
एक कोई देयर इज नो एनी रिस्पांसिबल बिहेवियर फ्रॉम दैट पार्ट.
अभी इसका जवाब लेंगे इनसे. I wanted to ask you the last question, since I have some certain rights. The Indian law and law world over is supposed to be reformative. We send people to jail and expect them to come back in a better shape than they were sent in. But these laws, do you think the intent, unstated intent, is actually to keep more people in jail and not to ensure that they come back as reformed people?
Yeah, so I think this is a really valid point, and this is the biggest missed opportunity of this law, because the fact of the matter is that if we really want to decolonize, which is the stated aim of this law, then we have to try and see that how we can reform citizens, not see citizens as persons who are incarcerated. But if we were to take the single most symbolic sort of motive of the colonial state, that is the death penalty. Right? That the colonial state could hang a native for certain offenses. So the IPC had the death penalty in 11 offenses. The BNS has the death penalty in 15 offenses. So it has increased it by 4. So reformation, I think I can rest my case here. Reformation is not the goal here. It is a missed opportunity. But the impulse of decolonization, if that impulse remains true, then we all can use that as a lever to try and move criminal laws towards reformation rather than incarceration.
So we are completely out of time, and this has been a fantastic discussion, but unfortunately we have to end it here. Many thanks to our wonderful panelists, Arghya Sengupta, Sanjay Hegde, Akash Banerjee, Jyotika Kalra, and of course Paranjoy Guha Thakurta. Thank you, Manish, for moderating the discussion so expertly. Thank you to the audience. You've been fantastic. And thank you all, as always, to IIC for supporting our media dialogues. Just one announcement, Media Foundation is open for membership. If anybody's interested, please, you can get in touch with us on our website, themediafoundation.in, or you could leave your names in the register outside. Thank you very much and good night.
Thank you, sir.